They just said bill amending SBX 211 and related government code sections, establishing State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power. Please tell the legislature to sponsor and support the Dr. Richard I. Fine bill amending SBX 211 and related government code sections, establishing State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power.
Yeah, he reposted what we have.
Yep. So today's show will be about talking about what Richard I. Fine is doing to address the need for compensation of victims who've been harmed by judicial corruption in the state of California. The judges in California were receiving monies from and incentives from the county governments in which they were operating, which was against the law. I'm not sure he was sentenced. He was thrown in jail by the California Bar Association. I want to thank reporter Janet Fallon, perhaps Phelan is it might be pronounced. My apologies. And that was from Activist Post. And I want to thank Roger Holmes, who did some important work in promoting and getting us all together to make this show possible.
I know. Well, it just shows that two people working together can accomplish anything.
Yes, I like that.
I was on a phone call with someone that was saying, well, this legislation is hard to get through and everything else. And I reminded her of the Margaret Mead saying that never doubt that dedicated citizens, can accomplish anything. It's the only way that things happen. That's just sort of a paraphrase, but
yes,
it's true.
So we have here Dr. Richard I. Fine, and he is he's going to tell us a little bit about his experience and what he's trying to do, what he is doing with proposing emergency legislation in the state of California to help with victims' compensation, people who are victims of judicial corruption. I hope I'm saying all that right.
Yeah. Okay. How do you want to go about it? What would you like? What would you like me to do? Do you want history background, or should we get right into the bill?
I think maybe we should get right into the bill. We should give some people some action items. The man that you see here, Richard I. Fine, has spent 18 months in jail, and I don't even think they didn't even really sentence you for anything, right? They just put.
They didn't. What happened was, I'll take you back to the beginning of the story.
Let's get to the. Let's not go into the story yet. I think we should give them the action items first, so they realize that there's a timeline to get this information to the legislators and say, hey, we're behind this idea to provide funding for victims of judicial corruption.
The timeline runs as follows. Basically, what happened in the mid-1980s, the County of Los Angeles, followed by other counties, decided that they were going to pay the state judges, California state judges, and in particular the California Superior Court judges, which is your local trial court, money above and beyond their state compensation. That starts it. Okay. And that went on until I exposed that in the year 2000. I'll skip the story of how I found out. I exposed it in 2000. What then next occurs is that that lawsuit exposing it gets knocked out due to judicial corruption. The Judicial Watch, with whom I'm friendly, I was friendly with a person in Southern California, in fact, copies my complaint in 2006. They bring it, and they get lucky, and they find a judge in the Court of Appeal who's a former Deputy California Assistant Deputy California Attorney General. That judge rules that these payments violate Article 6, Section 19 of the California Constitution, which was one of the things that I had in my complaint. Okay, so that ruling comes down. The California Supreme Court denies what they call a petition for review, so the ruling holds. That was October 2008. The LA judges pay $10,000 to a lobbyist, and that lobbyist comes in February 2009, and he goes to the President Pro Tem of the California State Senate, whose name was Darrell Steinberg, and Darrell Steinberg puts through a bill called SBX 211, and in that bill, they make the payments legal, and they give retroactive immunity from civil liability, criminal prosecution, and disciplinary action to all the people that were on the payment side, in other words, the county supervisors, and any employee, and all the judges who received the payments. And then they asked the Judicial Council of California to go in and make a report about the disparity between the payments of those people that were getting the payments and those people that weren't getting the payments. And that report comes out in December 2009. From that point onwards, all the way up until today, those payments are in there. Judicial Watch brings a second suit saying that SBX 211 is illegal.
So let me ask this because so that report, there was a report that actually listed the payments, the payments that happened, and who they were paid to.
Yeah, in that report, and it was Appendix D. D as in dog. It showed every county that. Sorry about this. My phone keeps ringing. There's no way that I can turn the damn thing off. Actually, I can. I've been doing it right now. Okay, the phone's gone. Nobody's going to bother us. Okay. Yes, it had an appendix, and it showed that there are 58 counties in California. 31 of those counties had either payments from the county itself or from the court in the county. And that accounted for 90% of the Superior Court judges in California were getting these illegal payments. So, and it said how much for the year 2008, how much money was being given by either the court or the county or both. So it plugged it right in. You could tell exactly how much was being given. And the payments were being given in three parts. One part was called, was basically, it was not cottage payments, but something like that. And that was the payments for medical care and everything that the county was giving to their own employees. The second part was professional development, and that was $6,000 to $7,000 a year. I'm just giving you LA because they were the highest payments. And the third payments was a payment to the 401ks or the 457 Ks that the judges had independently. The totality of those payments came to 29% of the state's salary that the judges were getting from the state. That's started out around $35,000 a year. As of today, that is $70,000 a year, above and beyond the $204,000 a year that the judges are getting as their state compensation. So if you're a Superior Court judge in California, you're getting somewhere about $274,000 if you're in LA County. The governor of California gets $204,000. Great job. All right. Now, here's where it becomes tricky, because what happens is that if you're getting a county payment, district attorney is paid by the county. So when the district attorney prosecutes you, you have a county paid district attorney, and you're appearing in front of a county paid judge. And if you're poor and you have a public defender, you're defended by a county paid public defender. You can put together what's happening. You've lost right then and there. No chance. If you're in probate, you have a probate judge who's getting this money. The county has an interest in the probate because the property that's going to get sold and everything else, the county's going to get a higher tax on that. So they have an interest in that particular part. You're screwed. Once again, if anything happens on selling a property, if anything happens in family law, you have all these people in the family law court who are coming in where the county has an interest because they have these people coming in to assess the benefit for the children and all this other stuff. You lose. No question about what's going to be happening there. Juvenile court, same thing. You have a juvenile court, you have all these assessors coming in from the county, everything, they're all getting paid. You lose. You name it. Whatever court you're going to be in, the county has an interest, you're going to be losing. Right down the line. And so essentially what is taking place is that when a system takes place that is going against due process and everything, there's a United States Supreme Court case called Cooper versus Allen. And that case goes all the way back.
Cooper versus Allen?
Yeah. And that case goes all the way back to the Civil War. When after the Civil War, the South loses. But what the South does is does all these things through legislation and everything else, fighting to keep slavery going, keeping the whole system going prior to the Civil War. So the first cases come out and they basically say that you can't really go against the government. And it goes all the way further back to the formation of the United States, where the very first case that came out, the Supreme Court said, look, we interpret the law. What we say goes on the interpretation of the law. And it goes all the way up to Brown versus the School Board back in 1958 or so, where the South is again rebelling and wants to keep black children out of the schools and everything. And that's where it's Cooper versus Aaron, A-R-O-N.
Oh.
And what they said in Cooper versus Aaron, that when a state does this, they are warring against the Constitution. So what's happening in California and any other state that is doing this type of stuff, they are warring against United States Constitution. Cooper versus Aaron is good law today. So California is basically in a state, to use an analogy, to apartheid in South Africa, except for the quote apartheid here, it's extending across the board. It is not necessarily going against black people, it's going against everyone. It doesn't matter where you're at. It doesn't matter race, gender, religion, self-represented individuals. Could care less. No matter what category you're in, you're stuck because the judiciary right across the board is engaging in some type of misconduct against you. So given that background, there has to be some solution. Now, I'm going to take you to the next step. You now have all these people that are aggravated because they've had this judicial misconduct. There's another factor here. you have what is called as absolute judicial immunity. And this is not a statute. This goes all the way back to the 15th, 16th century in England, where it says that you can't sue a judge because that would interfere with the integrity of the court system. So now you have judges who don't have integrity have immunity against getting sued to protect the, quote, integrity of the judicial system. Beautiful irony. Well, that absolute judicial immunity exists to protect the judges, the clerks in the court that work for the judges because they're part of the administration of the system, the prosecutors who work to prosecute the people because they're part of the system, and as far as the politicians are concerned, they have qualified judicial immunity for the things that they do because of their political decisions. So all of this is in there. Now you have people who are going out, who are outraged, and they have no place to go other than to tell their stories. Nobody, for some reason, did not think of a solution. Judicial Watch now comes in with its second case. The first case was called Sturgeon versus the County of Los Angeles. They bring the second case called Sturgeon 2, saying SBX 211 is unconstitutional. The court responds, because there's a new judge in the Court of Appeal here, and they say, no, it is an interim solution. So it's not a permanent solution, it's only an interim solution, and as an interim solution, we are going to allow it, and it is up to the legislature to go in and make the change. That's the case comes down in 2010. So in 2010, the case comes down, legislature doesn't do anything. A new case comes along because now the new judges that have been elected after 2008, they want to get this money. And so the counties are now paying the money to the new judges. Judicial Watch comes in again and says, wait a minute, you can't do that. And in fact, the Legislative Council of California said the way the statute was worded, it did not account for the new judges. But the judges came out and said, no, the way we are interpreting it, we say that any person who becomes a judge in a court where these payments were made as of July 1st, 2008, must be on your side. My side is that.
I don't think so.
My phone isn't working. So anyway, stop. So they say, so any judge that is elected after 2008, according to the judges now wording of the statute, is incorporated to be able to get these payments. So there we sit. So that is in 2015. And then they say there are two groups that are inveighing against these payments. One is Judicial Watch, and the other one is a newspaper called the Daily Cause. And they cite to the article and everything else. And lo and behold, who wrote the article? None other than yours truly. So there we are. So now we're in this particular situation. And in the meantime, the judges go in and they try and get me disbarred. In 2003, they try, and I bring a motion of sort of summary judgment. And on the verge of my winning, they decide to withdraw their case in the interest of justice. In 2006, they come back secretly and they start the thing again. And that's the one that ends up going through. And it gets me on the verge of being disbarred. And in comes Judge Yap. And I am now representing. In the meantime, I have brought a number of suits against the county with respect to development that they were doing in an area called Marina Del Rey. So these suits all come. We're now in one of these suits. where a developer wants to develop a 200-unit apartment building up to 500 units. I'm retained by the condominium group next door to go in and stop this. We end up going into the Superior Court, and right before we go into this, well, right before we're in the Superior Court, I find out that the developer had paid money to the supervisors in order to get the thing through. Not a good thing to do because there's a law against that. And we're now in front of good old Judge Yaffe. The county moves to have the case dismissed because it took too long to ask for a trial. I move to get the case summary judgment on my side because the county was breaking the law. And then I'm held to be involuntarily removed from the bar pending a final disbarment. We're in this situation, and Judge Yaffe comes in and he's doing this thing. I put him on the stand. This is March of 2008, and I say, Judge Yaffe, is it true that you've gotten $860,000 from the county? Judge Yaffe says, yes. I say, wonderful. I disqualified him. He doesn't answer within 10 days. There's a law that says if you don't answer within 10 days, you've consented to disqualification, you're out. Judge Yaffe doesn't get off the bench. He enters a judgment against me for about $45,000 to pay the other side's legal fees, and they want to get my financials. I say, no, you can't do that because you're disqualified. You're no longer the judge, illegal judgment. So he then comes in and he orders a contempt hearing for my not giving my financials to support the unlawful judgment put in by the unlawful judge, who's not really a judge. So we go through the hearing, and he holds me in contempt, throws me in jail. And this type of contempt is good for as long as you live because it's coercive to get you to do something. And I'm not giving him the financials. So we go through 14 months of this. I'm now up on a writ of habeas corpus. I'm up in front of the United States Supreme Court, right up in front of there. And all of a sudden, Yaffe, after 14 months, says, "Oops, I made a mistake." I say, "You don't say." So 4 months later, on the 18th month,
this was the United States Supreme Court, or
before the United States Supreme Court comes out with his decision, he declares that he made a mistake. So that sort of voids out what the U.S. Supreme Court is going to do. And 4 months later, he lets me out.
Oh, and because if the Supreme Court had ruled in your favor, it would have really rolled through a lot more. So, I can see why he would bow out and
okay. So he lets me out, and so now I'm out, and he retires. So now he retires. The next thing that happens is that literally right after he retires, the Chief Justice of the California Supreme Court retires because he had received these illegal payments when he was a Superior Court judge. A year later, another member of the California Supreme Court retires because he had received the payments when he was a Superior Court judge. In fact, at the time of my disbarment, 4 out of the 7 California Supreme Court justices had received illegal payments while they were Superior Court judges. In the meantime, the state bar came in and
I'm sorry. I have some head trauma from in the past, I guess, metal toxicity, and I had my head stomped on back around 2009, and so sometimes I don't follow so well. Could you back up just a little bit?
Mm-hmm. Where's the part that you stopped following?
4 of 7 judges.
4 of the California Supreme Court had received illegal payments from the when they were Superior Court judges.
Oh, I see.
So now what happens is that in addition to that, the state bar, not the prosecuting part of the state bar, but the state bar itself came out and said the real reason why I was disbarred, charges were brought against me, but because I was against SBX 211, showing that it was an illegal bill. So then I brought 5 motions in the California Supreme Court to have the disbarment removed as a fraud upon the court. The state bar did not oppose any of those motions. And there's a rule that says if their opposition does not oppose, it's they deem that they have consented to the motion. That didn't bother the Supreme Court, California Supreme Court at all. They denied all 5 of the motions. So these are the things that happen. So this gives you a bit of the background of what's taking place here. Now, take the next section here. Everyone that, quote, got screwed over in all of these different types of cases, family law, probate law, my juvenile law, civil law, these people are screaming, and they have no place to go other than to tell their stories. So they're telling their stories on the various courtvictim.com, uglyjudge.com, all the roving room, all these different things, and they're telling about the judges. But no one went in to figure out the solution. And being close to this over this period of time and having, in another situation, I had closed down the California government. I stopped 26 years of budget crises.
Yes, I heard about that. You created a bill that made $1 billion available or something?
Yeah. Yes. And so
it was an emergency bill, as I remember reading. And that's kind of what you're doing here is creating emergency funding.
Yeah. It's the type of thing that, I'll put it to you this way, for all of us, all the people that went to college and ever took psychology, Psychology 101, you learn one basic lesson. That is, if you don't like the sandbox that you're in, you take your pail and your shovel and you go to another sandbox. And literally, that is the situation that we're in. Because when the judiciary is systematically or systemically corrupt, you're not going to win. I mean, and it's Einstein that said, or it's attributed to Einstein, doing the same thing over and over again, expecting a different result, is the definition of insanity. So for those people that are staying within the confines of the judiciary and fighting against the judiciary where you know you're going to lose, it's insanity. But unfortunately, that was the only game in town. People will talk about all sorts of other things and everything else, but that other game doesn't exist. So basically, we had to figure out, when I say we, people, not myself alone, had to figure out another solution. And when I looked at this, I said, well, the solution is to create an independent commission where the judiciary does not have any say whatsoever. And in that commission, that will oversee the judiciary, and it will compensate the victims of judicial misconduct and judicial abuse of power. So now we're at the legislation. First of all, you have to conceive of it. So the concept is now in. How are you going to do it? So, and here I'll sort of describe how the legislation works. So what I did is I looked at everything and I said, we have certain things that are in place. We have the Commission for Judicial Performance, and they receive complaints from people, and they're supposed to investigate the complaints and then do something with respect to the judge. Well, and that's in the California Constitution, but who's on that commission? First of all, the Chief Justice of the California Supreme Court. Second of all, some other justices that the Chief Justice appoints. And then you have people appointed by the President Pro Tem of the State Senate and by the Speaker of the Assembly. And they can appoint lawyers and other things. Bottom line, that commission, by the way it is set up, is already going to be biased in favor of the judges. Now you look at the history of that commission, and as you saw in the Janet Phelan's article, the last report that that commission did, or I think it's 2021 or 2020, they had 1,032 complaints. They did one, shall we say, disjudgment votes rather than disbarment. They removed one judge. They sent out 4 letters, and that was it for 1,032 complaints. I mean, that's basically nothing. Now, it was so bad that back in 2016, a group of us, I think there were about 30 of us in the group, went and sent letters to the state auditor. State auditor is an independent person, to have an investigation. They investigated, and they came out with I think it was about a 91-page report or something, showing that the Commission for Judicial and Performance literally does nothing. So you have that group in place. So part of what the commission that I've created does is oversees the judiciary. So how does it do that? It goes in and it says that for every person who receives an award as a victim of judicial misconduct, the controller pays out the money. And the controller reports that to the Commission on Judicial Performance. Now, the Commission on Judicial Performance has 6 months to do its investigation. And they have to report every 6 months what they've done with respect to this judge to the auditor. The auditor takes these reports, because they're now watching over the Commission on Judicial Performance. They take these reports, and every 6 months, they report to the legislature. So now the legislature now knows from the auditor what the Commission on Judicial Performance has done, and it's up to the legislature. They fund the Commission on Judicial Performance, so they know if they aren't doing anything, will take away their funds, because they don't have to go in and fund the group. It says they're funded by the legislature, but if they aren't doing anything, you cut back the funds, you punish them in those ways. And the commission oversees what all these people are doing. So they come in and make sure that everyone's doing the right thing. So that takes care of that oversight. The next thing is, how do you get the people paid? So the people will have a claim form that basically the commission will supply. The other thing is the commission has to have money to work. So there's a budget. Budgets presently in the legislation, it's $100 million a year. And that should be enough, to get the thing going and everything, because you're really looking at what would be hundreds of thousands of claims, because this thing is going all the way back to 1985. And in order to back what a claim is going to be, you're going to either have to show transcripts of what the judge did, what his bias was, or you're going to have his or her bias. You're going to have to show the actual documents, court documents, to show how the bias worked or how the illegal action worked. So you're going to have to show all of these things. It's going to have to be linked into the law and everything. So it's not an easy job for a person to do, particularly a lay person. So the commission will have people, employees, who will be able to help a person with their paperwork. So everything will be correct. And then there'll be a report made that, yes, it all fits and the people should be compensated. And the commission itself will be able to approve those things. So now we're next on who's going to be on the commission. And the commission is going to have the current governor. This commission is permanent, goes forever. The current governor or their designee, and it's going to have the current Speaker of the Assembly and their current designee. It's going to have the current President Pro Tem of the Senate and their current designee. So these are the politicians. But then it's going to have people who are representing the groups that have been biased, of which the bias has been against, with respect to gender, religion, self-representation, all these different types of things. And it'll be dealing people from the family court, activists in that area, activists in the probate court, activists in the juvenile court, activists in the civil court, all the different departments that are in the court system. There'll be representatives but it can't be a judge or anyone that was a judge. So it's going to be citizens, will be independent people. So you have 12 people on the commission. So the politicians and their designees can't control the commission, and the independent people will be able to do it. And the person that's going to appoint all of those people will be the chairman of the commission. Now, these are jobs. This isn't volunteer stuff. These people will all be paid at the same level as the governor of California is paid. That current level is $204,000 a year. So it's a good, well-paying job. It's going to take time, and that commission will exist and be totally independent. And my viewpoint, and I'm appointing myself as the first chairman, because that way I know it's set up right. Now, as being a commission member, an independent commission member, you're going to have a term. You can serve 2 terms. Each term is 4 years. After that, you're termed out. Bang, no more. Can't get back in again. So you'll always have a turnover of new people coming in there, so you won't have this long-term bureaucrat type thing coming in. You'll always have fresh blood coming in.
If someone's damages are more than the $100 million, can it be structured maybe so that it goes over time, so they get some payments?
No, we're paying them straight out, and because what it is that you get a certain amount for each violation. Like, I'll give you an example. Defamation pays out $1 million a year for each year that the defamation occurred. If it's fraud upon the court, it's a flat $10 million. So, and for all the causes of action that we have listed in the legislation, but then in addition to that, we have a catch-all. So if there's some cause of action that we haven't covered, the catch-all will go in and get that. So each cause of action is separate, because you may have multiple causes of action that they might have done to a person. You have fraud upon the court, you may have a defamation, you may have all these different things. So each one of those would be an independent reason to get paid. And I set the price so high so that basically the judiciary is going to feel it.
Yes.
And that means that the good judges, are going to look at the bad judges and say, as long as you guys keep this up, we're going to run out of our budgetary money, and we'll have to go to the legislature to get more money. But we have money. Right now, there's $97.5 billion in surplus. So there's money there, and the legislature is going to have to look and say, wait a minute, we've got this big possible deficit, so we better watch out as to what lagoons we want to fund or what pet projects we want to fund, because these victims are going to get paid according to this legislation. So you have that. Then we have one other thing.
Welcome back. Richard, I want to apologize. I put your name on the screen earlier in the show as Ralph. And because I'm from Wisconsin also, and I know the name Fine. I don't know details about it, but I remember
there's a judge in Milwaukee by the name of Ralph Fine.
Ralph Adam Fine. I remember his name. It was for some reason. Is any relation?
No, not at all. What part of Wisconsin are you from?
I'm from Milwaukee.
So am I.
Yeah. Wow.
Yeah. Where did you go to high school?
Well, out in Waukesha, Waukesha South. But
okay.
I went to Ralph Waldo Emerson Elementary for part of it. There was some 35th Street School, I think it was called, which isn't really on 35th Street, so that doesn't make sense. But that was near Silver Spring. I think that was memories of kindergarten.
No, it's I grew up in Milwaukee, and then I ended up going to the University of Wisconsin undergrad in Madison, and then from there I went off to University of Chicago for law school, to the LSE for the PhD. So yeah, both Milwaukee boys. So,
That's right.
well, that gives it's interesting because we come from basically the same moral context. So I think knowing that you're from Milwaukee, you can understand where I come from as to going through the things of taking on the government.
Yes.
And coming up with the legislation. And actually, at the time, well, I'm 82, so you're a lot younger than I am. But at the time that I was in Milwaukee actually, though Milwaukee had a socialist mayor, interestingly, it had the LaFollets.
Was that Carl Zeidler?
No, Zeidler was the mayor. I think I don't remember. Zeidler may have been the socialist mayor at that point. I know that we had socialist mayors in that period of time, but we had the tradition of the LaFollets, who were very, very progressive and everything. And I took a course in Madison. It was called Law and Society, and it basically was a course that showed how law developed in society. And the reason I'm mentioning it is because what we are doing here is we're taking a problem of society and we're showing how the law germinates. Because here's the problem, and once the problem gets big enough and people want it, it gets introduced by somewhat outer groups. It doesn't come in by the main parties and things. But basically, the United States doesn't really have the same amount of outer groups that it had years upon years ago. We're really stuck with two big parties, and other parties don't have representation, or they don't have the power to go in and develop ideas the way it was way back in the early 1900s and things on this order, where you have a great disparity of people's ideas in there because you had all these different ideas coming from different places. But it's still the same process. And the process that we are doing right here is we're taking things that people want and need, and what I'm doing is we're pushing it through the main parties. And the way that we're doing it, and this is the actual secret here, is that we're doing it by forcing the legislators to recognize these ideas at the only point in time that the legislators are vulnerable, election time. Because the rest of the time they don't listen to us. They even don't listen to us that much now, but they have a fear at this point in time, unless they're so popular within their district, that if they don't do something for the people, they may get thrown out of office. And particularly, take San Francisco, where they just threw the district attorney out of office. Take the situation of Gray Davis, governor of California, and he evidently wasn't serving what a lot of the people wanted him to do. He got recalled, and Schwarzenegger became the governor. So it is possible to get these things done, and one of the reasons that it is important that we get this done now, because of the fact that come September, when the new legislative session starts, legislators are going to be out stumping to go and get reelected. So they aren't going to be thinking about legislation. I mean, they might, if we could get them at that point. But starting the press now is going to get their ideas there. And once I go into the next thing, my next subject was going to be term limits, because my bill has term limits in it also. So that they can't stay around forever. And then we'll be dealing with how do we get the bill through, what are the mechanics of getting that done, and then putting it all together. And it goes back to Wisconsin, law and society. How do you get it through? You have so it's not just a bill coming out of nowhere. It's a bill that is reflecting the need of the people.
Right.
It's in the.
It's
Go ahead.
it's almost as if they wrote this immunity for for the judges who violated the financing laws, or I may not be saying that right, but uh, it's almost like they didn't fund the bill. Essentially, the judges were causing damage, and they didn't address the damage. They just gave them immunity. It's almost like we talked about that in Wisconsin a lot. There was this thing about unfunded mandates, and
Well, yeah, you caught it. I mean, this is the interesting part of SBX 211. They give the judges retroactive immunity from from civil liability, criminal prosecution, and disciplinary action. They give the same thing to the counties and everything, but nobody thought of the victims. So we have all these victims out. They could care less about the victims. And, the victims are the people that are just getting hurt left, right, and indifferent. But Steinberg didn't think of the victims, and yet he's the one that is the president pro tem of the Senate. He's the one that should be thinking about the people.
yes,
He didn't. We have to think about the people. I mean, this bill, the more you get into what's behind the bill, the more you're into Civics 101. I mean, it really goes back that far. How does government function? In a sense, how should government function? It's more than it's how should government function? What isn't government doing? How do we fix it? And what is the practical way of fixing it? Where are the pressure points? What few of them are there? What can we do to press those pressure points? And we know that the politicians don't really, in their heart, want to do this. And I usually don't make assumptions, but since they haven't done anything since 2010, I think we can safely make an assumption that this is not at the top of their legislative plan to help, to help the victims. So we have to raise that and make it part of the plan. So now let me just segue into term limits, because as long as we're doing this, we don't want these judges sitting around, bad judges sitting around for a long time, nor for that matter any judge. So I put in a 36-year term limit for a judge or justice, even if they start out as a Superior Court judge, which has a 6-year term limit, a 6-year limit each time. They could end up being 6 times being a Superior Court judge, or if they move up to be a Court of Appeals justice, that is a 12-year term limit, or a 12-year limit. So they could end up doing basically 2 terms as a Court of Appeal justice or a Supreme Court justice, which is also a 12-year thing. They could do 2 of those. That would be 24 years. And then they'd have another 12 years as having been a Superior Court judge, or 3 terms, any way you want to put the combination. And the reason that I chose 36 years was thanks to Jerry Brown. He appointed a Supreme Court justice who was 37 years old. Well, I mean, imagine this, a person who's 37 years old is a California Supreme Court justice. She had been a member of the bar for possibly 12 years, assuming that she graduated at law school and took the bar and passed it at age 25. So in order to give her an amount of time to serve out her term, say, shall we say 36 years, as a justice in the Supreme Court, I had to put in 36 years in order not to cut her short. Now, this also fits in with the judge's retirement plan. I don't know if you're aware of the retirement plan of the California judges is terrific. If they stay in at age 70 and they have 20 years in as a justice, they get 75% of their highest salary as their retirement. That is one of the greatest retirement plans you could ever imagine. So let's say that right now, a judge who's been around for 20 years and what they're getting as their base plan right now is $204,000. So they're getting 75% of that.
Oh, now is that
that's not counting the extra compensation.
That's what I was going to ask. Is the extra compensation part of the calculation?
Well, according to SPX 211, this extra money is considered compensation. So if you want to look at it, it's considered compensation, and it's now lawful compensation for the judge. That's going to be the compensation for the judge.
So this has effects on the retirement fund.
Oh yeah, it blows the retirement funds out. It just really out blows them out. And you can go in. I think it's the controller is now publishing the county by county what the judges make, and they don't put the name of the judge in, but they'll put in Judge 1, Judge 2, Judge 3, Judge 4, and they'll put in their compensation. And you look and you find some of them are really up there, because I guess they evidently have steps within the compensation. So it's your step compensation will start at one point, but if you have so many years, then you may go up to step 2, step 3, step 4. Just like the federal government has compensation in different steps, but then within the step you have sub-steps, and so you get increments depending on how many years you're in there. So yeah, it's really a heavy-duty thing. So that's where we're sitting at, and that's how the legislation developed, is to take charge of all of these different points that you have to look at and determine what are you going to do about all of these things, and also remove the problem of the judges having control of the courts. Because within the court system, there's nothing you can really do, because, as I said before, absolute judicial immunity started out in either the 15th or 16th century, because the king appointed the judges. So the judges are part of the state. The king has sovereign immunity. So absolute judicial immunity developed from the sovereign immunity that the king had. So they're saying, well, to keep the integrity of the system based upon the sovereign immunity of the king, these judges have absolute judicial immunity. And even today, the state has sovereign immunity. And the only way that you can sue the state is you can sue it because the state has given up their sovereign immunity in certain situations. And that allows you to sue the state of California. It allows you to sue the county of Los Angeles, the county of San Francisco, or any other county. And so that's the only way that you can sue them. Otherwise, if they didn't give it up by statute in certain situations, then you wouldn't be able to sue them. So that gives you sort of a background as to where we're at, how we get around it. That's just my wife on the pots and pans. And
hope she's okay.
Yes, she is. And how we're getting around it, and how we're getting it out of the court system and into the other balance, because you have in government, you have the executive, you have the legislative, and you have the judicial. So each balances the other, and we're now putting the balance into the legislature to balance out the judiciary, because if the judiciary makes a decision, the legislature can always pass a law to take care of that decision. So that sort of gives you the balances and everything. So I'm sort of finished on the description.
So would someone contact their legislators and say, we like what Richard I. Fine is proposing as an amendment to
SPX 211.
Is it SP as in Paul? SP?
No, SB as in boy.
Oh.
X is as in Xavier. And S is in Sam.
Okay.
SBX, and then a space, no underscoring, just a space, and then 211. Now, let's get into the practicality of how they can contact their legislator. First of all, they can go in and they go online, and online it'll say, who is my legislator for the state of California? They put in their address, and they'll get a listing as to who their state assembly person is and who their state senator is. You then go to that listing, and this becomes very interesting. Neither the assembly people nor the senators give you their email. Oh. They all have a little box that says fill in your name, your address, and then they have all these issues that they would like to have you comment on. But then they have another thing called other. And in the other, you tell them that you want them to sponsor or introduce or support the legislation, and you put in the name of the bill, the State Commission for Judicial Oversight and Compensation to Victims of Judicial Misconduct and Judicial Abuse of Power.
In the chat room, it says bill amending SBX 211. Oh, I see is there space intended between the 2 and the 11?
Mm-hmm, yeah. Mm-hmm.
Okay. And related government code sections. Let's see what this looks like up there. Establishing State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power. Please tell the legislator to sponsor and support the Dr. Richard I. Fine bill amending SBX 211 and related government code sections, establishing a State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power.
That's all they have to say.
Nice.
They get enough of those, and they're getting them from their own people, and so all they have to do is just, they could just copy it and then paste it right into the little box.
I'm if you've got this on the screen, and if you know how to do snapshots, if you're listening to the show right now and you take a snapshot of that screen, you'll have it. You can go back and look at the picture. So there you go. Otherwise, it's in the comment area.
Okay. Well, it's easy to do, and then also tell all your friends, relatives, acquaintances to do the same thing. In fact, a very easy way to get things going is send out 10 emails to tell 10 people to do it, and then tell each of them to send out 10 emails. And the next thing you know, you have thousands of people that are noticed. Someone could have just sent out the 10 emails. It's the underground way of getting things done.
Yeah.
Because you have a lot of people using petitions and things, but it takes a long time to get a lot of signatures on a petition, and the petition isn't geared to each individual legislator. So a legislator can see a big petition, but that legislature will say to themselves, how does this really reflect to me? What are my constituents saying to me about this? If I see 50,000 signatures and I don't know if any of them are in my district, so what does my district think about it?
What if a person, lived in California, was and perhaps had this kind of damage, but doesn't live there anymore, doesn't have a California representative? Would that be something where you might, who might you contact?
That becomes a problem because the representative doesn't doesn't represent them anymore. But what they could do is they could take their former address and say, I formerly lived in your district and voted for you.
Hmm.
And this is what I'd like you to do.
I suppose
Yeah.
that might work, or the place where I was, or where one was injured.
And the other thing, if they contributed to the legislator, or even may even still be contributing to that legislator because they like them. Because I get things actually from both parties, and I'm not a major contributor to parties. In fact, I'm not even a minimal contributor to both parties. I don't know how I got on their lists because I was a registered independent, but maybe that's how I got on. Maybe both sides are sending things to all the independents.
Yeah,
and
yeah.
every day I get stuff. I get things coming out of Georgia and Texas. They must have a national list somewhere of all independents, and every day I'm getting stuff, for people outside of California asking me to contribute to their campaigns. I have no idea where that comes from.
I remember it was about September of 2000, and no, it wasn't that late. Maybe it was September 2009, when I think I heard the news about you being locked up. And there
It was
was
actually March of 2009 when they locked me up.
okay. Yeah, that's about when I arrived in California, and we were all deeply saddened about it all. Um, it's very interesting that we get to do this show today, and I'm so glad you're out. And it looks like you may have the upper hand on this whole thing at some point.
I hope so. I mean, I think I guess the interesting thing of it is that I growing up in Wisconsin. Wisconsin was a very clean state. I don't know what it's like now because I basically left at age 21 to go off to law school and really never came back other than to visit my parents. And so, and you remember Wisconsin. Like, to me, Wisconsin we had policemen that walked a beat, and the policemen knew everyone on the block. So you didn't have this problem of police being against the community. I mean, that didn't take place. Everyone knew each other. It was, so you had that whole. It was just different. And if you needed something, you could go to the government. You need a piece of paper or something else, and the people that were there helped you. It wasn't, there wasn't that great divide between the bureaucracy and the people, and that's what I grew up with. And it's difficult. I won't say it's difficult. It's disappointing to see what happens after that. And the University of Wisconsin in Madison wasn't as large as it is now. It was much smaller. And I'll just sort of give you an interesting story. I started out in pre-med, and I took a course in labor history from a professor, Stephen Perlman, who was known as, at that point in time, one of the best professors in labor in the United States. And he had the class at his house. And there were 5 people in the class. 4 of them were graduate students. And the other one was this 18-year-old kid who was a sophomore in college. And Professor Steve would refer to everyone as Mr. Now, I'm 18 years old. I'm so wet behind the ears, and he's calling me Mr.
Yes.
And he said to me, Mr. Fine, he said, what's your major? And I said, well, it's pre-med. And he said, you have a very interesting mind. He said, I'm sure you'd make a wonderful doctor. He said, but you may want to think of going into political science or law. He says, because there, you could probably do things that could change the world. He's telling that to an 18-year-old child. And when the time came for me to make a choice, I elected to go to law school. And I got lucky, and I got into the University of Chicago. And then from there, I got lucky. I'd always wanted to go to the London School of Economics because I had heard about it and everything. And I had a law professor that wrote a letter.
What did you hear about the London School of Economics? What drew you to it?
The London School of Economics had a reputation of two things. One of it was the reputation of being the most eminent place for economics in the world. The other part of it is that it was basically the international finishing school for things like international law. And my PhD was in international law. Now, I never intended to go to get a PhD. I mean, this becomes a very interesting story. I went to get a master's in law, and my thesis was on common market antitrust law. But the thesis got large. It became 400 pages. And my professor, because there you work with a single professor, and my professor said, this is too big for a master's in law. He said, you should really think of going for a PhD. So I ended up getting PhD registration, but the thesis, that alone wouldn't get you a PhD. So we expanded it, and I looked at all the antitrust laws throughout the world. Now, so I surveyed all the antitrust laws throughout the world. That would have gotten me a PhD at any American university. But he said to me, now we have to do something more. And that is rationalize all these different things throughout the world. I called it 14 Ways to Screw the Other Guy in International Commerce. So it showed what the price fixing was across the world. I drafted a treaty. And
wow.
Basically, so now I had to defend the treaty. And here's the difference between the British education and the American education. In the American education, you defend your thesis in front of a committee. In the British education, you defend your thesis with respect to one person in the entire British and Commonwealth system who's an expert in your field. And they brought in the person that had drafted, I think it was 1949 or 1950, United Nations Treaty on Restrictive Practices. And you have tea in your professor's office. So we come in and we're having tea. My thesis had 2 volumes to it. There's the backup volume showing all the laws of the world, and the written volume, which was the thesis. And we're having tea and we're talking about international law. We're talking about human rights. We're talking about all these different things. And finally, he had all these paper clips in it. And finally, he said, I think I ought to ask you about your thesis. And I said to myself, okay, here it comes. And he says, on page such and such of your thesis, you quote Article 177 of the Treaty of the European Court of Justice, and you use the word may. You say the court may do something. And he said, why did you use the word may? I said, first of all, the court had the power to do it. So I didn't have to use the word should or could, because they had the willingness to do it. It was their choice as to what they wanted to do. So the word that described that was may. I used the word may. The court may do this. And he said, thank you very much. Close the thing. I said, it's over. And I said, what? He said, yeah. He said, you passed. Then I got a thing saying that I'm written in the book, because they don't give out diplomas. You're written in the book. So now that's not going to satisfy parents in the United States, because who knows where the book is? Or if this. So I said, look, we got a problem here, because I need something that says I have this degree. So they sent me this very nice thing with a little emblem and everything else, and it's saying, you've awarded a PhD, your thesis may be published in a British form and everything. And now I get these things saying Dr. Doctor, because degree from the University of Chicago was a Doctor of Law, and now I have a PhD, and so that was it. And I can tell you that the London School of Economics, in the graduate part of it, you have people from all over the world coming in there and studying all these different things. It was really one of the more exciting places to be, just by the friends that were there. Some of them went on to become prime ministers of their countries. Some of them went on to become professors in different places. But to be there at that point in time, and I was 24 when I graduated law school, so I was in London. It took me 3 years to do the PhD. And in that 3 years, you're in that age where you have phenomenal political discussions, you're intense about a lot of things, and you're getting the viewpoint from all these different places and everything. And your professors came from all over. So it was really interesting. But in addition to that, being from Milwaukee, I wasn't going to waste a lot of time, because we had 6 weeks in the springtime and a long summer vacation. We had basically a number of weeks at Christmas time. So what happened is, in those vacations, I went to the International Comparative University in Luxembourg, and I got a certificate in comparative law. I went to The Hague, and I got certificates in public international law and private international law. I went to the International Faculty for the teaching of comparative law. I got a higher diploma in comparative law, and I studied in Paris, Strasbourg, Coimbra, Cagliari.
Oh, so thank you for taking us through a little bit of that in the back. The backstory of all this stuff is so interesting, that people recognize that your mind had, some really great talents, and that you could potentially change the world.
Well, that's what I thought was so funny. I mean, this professor just, he was the nicest person. And that's what education is for some teacher to tell you, look, you're thinking of doing one thing in your life, and you have the opportunity to do something else. And who knew? Because I went off, closed down the California government, stopped 26 years of budget crises. Get the other thing that I think you mentioned. It's the,
I didn't get that. Could you try again?
Ended up, doing all this money that they took illegally out of special funds and trust funds. Got that back, and you're right. At this point in time, it's probably over $1 billion. They changed the way that United Way functions. Stopped them from taking your money and doing what they wanted to do with it, and made them go in and allow you to designate where you wanted your money to go. Reorganized the Japanese religion worldwide.
Wow.
It's just amazing. But what I find interesting, and I think interesting for you and I, because we're both from Milwaukee, kids out of Milwaukee, Wisconsin. I mean, I think my mother's dream for me was to become a lawyer, be in Milwaukee, be a lawyer in Milwaukee, and maybe sell some real estate on the side, or insurance, and everything. But these opportunities are there, and all that comes together to be able to do this legislation. But where does it come from to be able to put this legislation together? It comes from all of these different things that happened. And one of the things that all of that taught me is respect for the individual. And one of the things that I recognize, and I say this about the judges, if those judges had to live through 18 months of solitary coercive confinement in a jail cell, which is 11 feet by 8 feet by 13 feet, and only get out of that cell 10 times, at which point you're in a cage, they wouldn't have made it. Because they are so arrogant that their mind could not be able to grasp being able to take, shall we say, that type of punishment and make it through. You have to have an ability to be able to deal with these things, and that ability comes from having respect for people at all levels. Doesn't matter what level you're dealing with, because in the course of my life, I was also consul general for Norway for 15 years. So we've met with kings and queens. We've met where, as my wife puts it, she says, Richard, she says, people smile at you, and I say, they smile at me. She says, because you smile at everyone, and you'll say hello to people on the street. People don't do that.
That's a Milwaukee thing. That's a Milwaukee thing.
Exactly, it's a Milwaukee thing. You walk down the street and you say hello to people, and it's just and I'll just sort of put a little story. And I was in the Vaughn supermarket yesterday, and I have had a hip replacement, so I have a cane. And there was a guy in the movable carts, the little carts when you can't walk anymore. And you have in the grocery store, they have the cart. You go in the cart.
Motorized.
And he was at the freezer for milk, and he was, and I saw him there. I was in the next freezer, and I said, "What can I get for you?" And he told me, we talked of which milk did he want. I gave him the milk and everything.
Yeah.
He said, "Yeah." He says, "We guys said we have to help each other." I said, "Yeah." It wasn't even a thought about walking past him without asking him what help did he need. I mean, it's just it's that type of thing in the world.
It creates value. You really create value when you respect someone else and engage with them and help out their needs.
And that's really what that goes into the basis of this legislation, and really thinking what has to be done, solve the problem, and then go on and take it as far out as you can take it, even to the point of saying what to look for. Look in the little box, and here's what you put in the little box.
Would your amendment allow for creation of financial instruments?
No, that's in a whole different area. I mean, like it's you're now looking at things like Bitcoin and Ethereum and stuff on this sort of, like Bitcoin is a financial instrument. So you're going to be looking at the government. Let's take the state of California. First of all, they can't create a financial instrument because it's against the Constitution. But so we'll take the United States. United States isn't their financial instrument. They have bonds. They have treasury bills. They have the dollar. The dollar's floating against other currencies. Now, they could, if they wanted to, probably create another official financial instrument. I think they have the power within the Constitution to be able to do that. But outside of the United States, you already have financial instruments that are created. You have Bitcoin, you have Ethereum, you have all the NFTs. So these are basically functioning as financial instruments. In fact, if you look at Tesla, you can buy a Tesla with Bitcoin. You can, out here in California, there are stores that are actually accepting Bitcoin, and you actually have machines that will trade in Bitcoin.
Isn't a judgment a financial instrument?
In a sense, a judgment is, because you can buy and sell judgments. I mean, so depending upon how you want to describe the financial instrument and what definition you want to put in it, but the fact that you can trade it, people buy judgments, and then they go out and they enforce the judgment. Things on this sort of that's very common. There are companies out there that buy judgments.
What I would like to create is a marketplace for forgiveness judgments. In other words, that the person that the two parties and the judge look at the matter, describe how much damage there was, and when the person just issues forgiveness of it, so that the person who did the harm doesn't pay, isn't harmed in any way. But all these people, these minds coming together, can certify that, yeah, there's something of value here, uh, and that demands a debt. But if someone is kind enough to issue forgiveness of it, that we could encapsulate that, and that then those judgments could go on the marketplace.
Well, you have to establish some type of value in the sense of, I mean, would that judgment be backed by gold, or
It's backed by the infinite worth of, and I'm getting off on this something that maybe I shouldn't, but it's not controversial. So it's I've found that individuals have infinite worth, and that when they're damaged, they can forgive that. They can give more of themselves to compensate for what their loss is, and that in the instance of doing that, if you encapsulate it with documentation, and then you could create it, like you say, an NFT or something of the "I forgive you" note, and then see how the market would engage it.
you, yeah, you could do that. I mean, there's no question that you just described something that can be done. The next question is, how is that value manifested other than the fact as a forgiveness value? See, because the interesting thing, and this is probably a subject for a whole different
Oh yeah.
Another hour or so, and it would only be me speculating. I mean, we'd have to put together people that are in the business of doing this type of stuff.
Yeah.
So, but but remember, you're talking to a guy that basically believes that anything can be done. I mean, we are only limited by our belief of what we can do, and also you're talking to a person that says, I'm not afraid to fail, because fail will only teach a lesson as to how to do it better next time. It's another Milwaukee thing, I think.
Yeah. Yeah.
So, I mean, you may be talking to a minority of people when you're talking to me about these things, but you can do it. That's my viewpoint, is that it can be done. Just like in talking to legislators, going back to the legislation, they want to put things off because they don't want to do anything now. They like to put it off, and hopefully it'll go away. My viewpoint is we want to get this thing done now, because now is the time. This is like the perfect storm. Election time, they need us. And this is about the only time where we have the opportunity to put the pressure on them, and they would like to resist the pressure and hope it goes away. But I learned one thing in dealing with politicians from the lawsuit point of view: they will do everything possible to block you until they give up, till they run out of options. At which point they give in and settle. But until they reach that point that they've run out of all options that they can use, they're going to fight you tooth and nail. And the same thing here with this legislation. I mean, they're basically very intransigent. They don't want to do something, even though they're elected to do something. They will do what they want to do based upon what they say they're going to do in their platform. And people are hesitant to go in and ask them to do something, because the first answer is no.
Yeah.
And you have to go through a lot of no's before you get a yes. It's very strange. The first answer should be, we can do it, we just have to find the way.
Right. So let's see. We had a comment from Robert Gettinger, and I think he basically reposted everything that you wrote. Maybe it's a little different, but I'm going to put it up on the screen here. I wish I could. They just said bill amending SBX 211 and related government code sections, establishing State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power. Please tell the legislature to sponsor and support the Dr. Richard I. Fine bill amending SBX 211 and related government code sections, establishing a State of California Commission on Judicial Oversight and Victims' Compensation for Judicial Misconduct and Judicial Abuse of Power.
Yeah, he reposted what we have.
Yep. Well, it does. It's good to restate that. It kind of refocuses our attention on the matter at hand. Yeah, it's very interesting. Wisconsin's had some really dynamic people. I think wasn't the Progressive Party created here, and the Republican Party was created here?
Well, Will Follett created the Progressive Party, and it wasn't. And it's very interesting because when you look at what the Progressive Party did, that is so mainstream now. I mean, it's basically very, and even. But the other interesting thing is that what the Socialist Party in Wisconsin was is also very mainstream. It's all of that is really integrated into our basic society, and that's why that course that I go back to that I took also I think in my sophomore year, Law and Society, the movement of law and how it developed politically. And I took another course way back when, and that was a course which was constitutional law, but constitutional law as taught from a political science point of view. So it wasn't necessarily the law part of it, but it was the law part of it within the society. What is the effect? How do these cases come about and everything from a political science point of view? And that's what is happening here. This legislation is not coming so much from the law. It's coming from the political science point of view. This is the problem that has to be solved. How are we going to solve it? The law happens to be in the way. So therefore, we'll change the law. It's really that simple. And a lot of people forget about that. They forget that, and I learned this from one of my professors. His name was René David. He was a French professor. And he basically said, you take everything and break it down to its minute parts so that it can be understood. And when you run into these people that give you a lot of gobbledygook and everything else, you can almost look at them and say that they haven't finished their education. And when I use the word education, I don't mean schooling. I mean, it's your life education, because if you can't break it down into its basic morality and its basic ethics and basic life experiences, you haven't gone the full round. I mean, and I'll give you an example. Many years ago, I wrote a piece, it was a law review article. It was called Mailbox Magic. And the difference was, it was the difference between contracts by correspondence in the Anglo-American system and the European system, and basically the Swiss system and socialist system, which is a mix of the two. And the difference is the following: is what happens in the Anglo-American system, if someone sends you an offer, in other words, they offer to sell you something, and you send an acceptance. Under the Anglo-American system, the contract is consummated at the time that they put the acceptance into the mail, before it even reaches you. In the European system, the contract is consummated when their acceptance reaches you. Now, why does that difference occur? It's a very simple reason. Because in the Anglo-American system, we believe in the post office. And by believing in the post office, we believe that if you put it into the mail, it's going to get there. And therefore, the contract is consummated at the time you drop it into the post office. The Europeans didn't believe that. They didn't have such faith in their government. So they said it's not going to be consummated until the offeror receives it. It was the belief in government. We believed in our government, and therefore acceptance takes place when you drop it in the mail. European system, nope. We don't believe in the government, so we don't know if it's going to get there. Therefore, acceptance doesn't take place until the guy actually receives the acceptance.
Wow.
Political undertone.
So this is what you mean when you talk about comparative law.
Yeah, because comparative law is looking at the laws of the different countries and seeing, each of them may have somewhat of the same words, but what is the political undertone as to what happens under those words? So all of this, it's coming in, but believe it or not, all of this is in this legislation. I think this is where Janet sort of hit it in her article, where she says the article looks very straightforward or bureaucratic in the title, but what's really behind all of that? How does it come together, and what are you really looking at? And it turns out that SBX 211 was a very, very straightforward bill. Sort of said, help the judges screw the people. That was it. There's nothing to it. The cure had to go in and take into account everyone. And that's why some of the legislators might be afraid of it. They might be afraid to move on it. Who knows? We don't know that. But if they really look at it, it's a good thing.
Right. And even if they don't necessarily take your version of it or whatever, there's it's going to shine a spotlight on a whole that there's a lot of people who've been damaged and seem to have no hope of remedy.
Yeah. And the thing that most people who are damaged, the damage is so great for many of them. What's happened to people is just amazing that they really can't get beyond that. And understandably, because they've been hit so badly that a lot of them just can't recover. And that is a totally understandable thing. But then there's other things, like I have a friend who said to me, because my life has gone up and down, and he said, Richard, guys like you and I, he said, we make it, we lose it, and we make it again. He said, that's God's word. He said, that's it. And you have to, there's certain belief systems, and I have a belief system that I believe in a God, and God gives you opportunities. It's up to you to follow up with them. And there's a very famous parable, and I'll give it to you because I think it really hits the point, is that this person was sailing the ocean, and all of a sudden the storm came, and his boat was destroyed. And he's now in the ocean, and he's saying, God save me. And here he's in the ocean, and all of a sudden, a yacht comes along, and the person, they say, jump on, And he says, no, God's going to save me. The yacht goes away. Next thing, a super tanker comes along. The super tanker says, and they come by, and they throw a ladder over the side. Jump on. He says, no, God's going to save me. Super tanker goes away. Third thing, an air rescue plane, helicopter comes. Drop the ladder down. They say, jump on. He says, no, God's going to save me. Well, he drowns. He ends up coming to the pearly gates, and he goes in, he sees St. Peter, and then he goes up, and he goes to God, And he says, God, he said, I asked you to save me, and you didn't. And God responds to him, look, I sent you a yacht. I sent you a super tanker. I sent you a rescue helicopter. He said, I saved you 3 times. I gave you the opportunity. You did nothing.
Mm.
Well, that's my way of looking at things. Everything that happens to you has 2 sides to it: tragedy and opportunity. And you just really have to deal with the tragedy and look at the opportunity. And I prefer to look at the opportunity. And I just really look in the sense of what has happened to my life. And it still isn't over yet, because my dad lived until he was 96, so I've got 14 years to go. Is that phenomenal things have happened to it, in it, and some bad things have happened. And I prefer to remember the more phenomenal things. I lived through the bad things. But I'm an optimist. And I think people can make things happen. All of us have different abilities in different areas. I cannot conduct brain surgery. I recognize that. That is one of my limitations. But I can do other things. And in those things where I can do things, it can be unlimited. Just keep going and keep going. And I'll give you another sort of thing. At one point in my 30s, I took up flying.
You took up what? Flying.
Flying single-engine airplanes. And I learned one thing about that, and that is that I was a risk taker. And so I didn't go forward to get my the license that allows me to fly in bad weather, my instrument license. And the reason I didn't do that is that I knew that if I did do that, what would happen is I would probably take off in bad weather and kill myself. So I stayed with the other thing, so I could fly 3rd-degree radar and everything else on this order. But whenever I was going into something where I'd have to be on instruments, I always had an instrument pilot with me, so that we had the 2 of us, so that he would handle the plane, I would handle the radio, or I would handle the plane, he would handle the radio. But I had that certain thing with me. And as he always put it, he said, Richard, he said, I am the best thing that could happen to you, so you better believe it. Because I used the plane I represented a ranch up in Mendocino, so I would take off from Santa Monica at 7 o'clock in the morning with the pilot. I'd work all day. We'd fly back that night. Well, you do that, you're tired. You're going to crash. You learn your limitations. It's really that simple. So you learn these different lessons. But the things that you can do, you are unlimited until you reach that point where the limitation is going to take place. But up until that point, you are unlimited in what you can do. And those, and that's built into this legislation. Since we couldn't get it done in a court system that has systemic problems in it, and those problems happen to be corruption, we found another way. There was another opening. It's really that simple. In some ways, maybe very Milwaukee.
Yes.
I think Midwesterners we grew up with a little bit of a different, I would say a different sense of ethics. We grew up with a good sense of ethics. And we also grew up with lack of bluster. And
what's that?
I put it to you this way. If you're dealing with a New Yorker and he kills you, he'll slash your throat and you immediately know that you're dead. If you're dealing with a Midwesterner he'll take out your insides and you'll keep walking along and not realize you're dead until a long ways afterwards. And I think that's sort of the difference between the Midwest and the East. We're far more subtle.
Yeah.
In the way that we do things, and I think Janet caught on to that. When you look at the bill, you look at the title of the bill, and the title of the bill tells you exactly what's happening. But when you read the bill and you see how it all happens, you realize that the bill goes a lot deeper in what it's doing. And then you realize I have the examples in the bill, because people seeing the bill, seeing the title, and even reading the bill, they don't have an ability to associate. So the only way that people can associate with the bill is to be able to see the examples. And when you read the examples of what happened to the different people in there, then you really see what is happening. I'll use one of the family stories with Felice Reyes. She has this judge, and the judge goes in and he does all these things to her. It's one of these things where the judge doesn't get off the case. And then the judge says that he wasn't served with his disqualification because he isn't around. So he wasn't in the courtroom. But then we go in and we do a public information request. We get all the documents. The judge was there. He was lying. But you had to go in and do all this type of stuff to show he was lying. And then what turns out with this judge? This judge becomes the head of the family law division. So who do you have running the whole family law division? A judge that's in there lying. I mean,
does this? There's a word. If I can hold the question till later if you want to continue with.
No, go ahead.
All right. So the California legislature put this law into, or made this change to allow the judges to receive these illegal monies, changing it from illegal to legal because of their dictate. And then because if they didn't do that, the judges would be what is it, invalid, or
well, if they didn't do that, the judges were subject to being indicted under California law for both accepting bribes and interfering with the administration of justice. One's a felony and one is a misdemeanor. And under federal law, they would be indicted for the intention, for the taking of money illegally, and that is both. And there's case law out there. It says both bribery and the taking of money from services. Both of those are felonies. And even today, even with the law being a law in California that they can do that, they are still violating the federal law. It's like the marijuana situation, in California. In California, marijuana and everything is legal commercially, and yet under federal law, it's illegal. So the judges are in exactly that position.
So there's the one thing is perjury is an example of something that would make someone's testimony invalid. I'm wondering if does perjury make your your judgments and all these types of things? Does it void all the judgments you made in the past and at the present?
Perjury comes in a little bit of a different thing. The perjury itself is something of a witness lying on the stand. That may not invalidate the judgment, it just invalidates the witness's testimony. But what is known as fraud upon the court will invalidate the judgment. So if you as fraud upon the court has certain things to it. Fraud upon the court is basically the interference with a party's ability to present their case. And that can be done by either your lawyer or someone else's lawyer stopping your ability to present evidence or doing various things. Usually it's the ability, stopping the ability to present your evidence. And if that takes place, then the judgment is void. And even if you find out about that years later, it still would make the judgment void. So the main case of that, and I can't remember the name of it right now, is it's Hazel Atlas versus someone versus the Hazel Atlas Glass Company. And they found out about it 26 years or 20 years after it occurred. And the courts held that these people lied about it. So they lied about their position and everything. Found out about it 20 years later. Came into the court by pulling that trick and presenting that fraud upon the court. The judgment was invalid. From the invalid all the way back to the beginning. So fraud upon the court is one of the most powerful things, but it's in very limited circumstances. Then there's just regular fraud, and that usually goes out. Statute of limitations on that runs 2 years if it's a verbal fraud, 4 years if it's a written fraud. And that will deal with contracts.
What I'm trying to get at is a tainting of the judge's ability to sit as a judge. It kind of like in a Brady request, when a defendant somehow enacts this Brady thing so that it makes the prosecution, in this case, like the state, have to provide as discovery any like information about
anything that could point to the innocence of the defendant.
Yeah. Well, not so much the innocence of the defendant, but the what is the word, culpability?
Well, anything that could show that what the prosecution is doing isn't correct.
Yeah.
I know the word you're thinking.
Well, that they're not reliable, that they're not reputable as telling the truth, and so.
Well, you have the same.
I'm sorry. I'm really.
I know what you're talking about.
Having trouble here.
You have the same thing with collateral action. I'll give you an example. In California, you have a law that says that if a party or their attorneys contribute more than $1,500 to the election campaign of the judge is automatically off the case. No, you don't even have to bring any motion or anything. The judge is gone. And then you put in the code of ethics, the judge actually has to tell you about it. The judge has to inform you of those things which put him off the case, whether the judge thinks it's relevant or not. So, and then you have a second thing that goes with that, and that is if an objective person thinks, let's take the money if the money is less than $1,500. If an objective person thinks that this contribution could bias the judge is automatically off the case. So these are what we call the collateral aspects. If the judge has a bias against your attorney, the judge is automatically off the case. So all of this is what is known as collateral aspects. And those things would remove a judge automatically by statute or as reasons for disqualification. Because for disqualification, you have certain things that can disqualify a judge. If you can show that, and these are some of the examples that we have in the legislation, and we used this one. There were two things. One guy got disbarred, and one guy got hit with $260 million of a loss for two things that happened. The $260 million is the better one because the judge there called the person it wasn't a snake, but it was something akin to a snake, which is a trope for anti-Semitism, straight on out. And then she ended up, relieving him of $260 million. So right then and there, that judge was gone, and she stayed on the case and did all that. So he has the claim against this judge for misconduct, even though the absolute judicial immunity says, well, okay, she did that, and even it was done with malice and everything else, you can't sue the judge. So under the judicial system, he couldn't sue her. But under the legislation, because she committed judicial misconduct, he gets the money. And same thing in the California Constitution, it says that a judge can be impeached, for misconduct. Yet the California legislature, in all of its history since 1849 or whatever it may have been, has never impeached a judge. And
that's exactly what I was looking for. The impeachment, I think, of the judge for this money that they've taken. We're getting the hang of this.
Yeah. So anyway, so to continue, in the United States, since the foundation, the forming of the country, there's only been 3 judges that have been impeached, even though the Congress has the right to impeach judges. So impeachment is something that is very seldom used. And see, once again, the legislation is taking care of the problem. Now, the judge may still be sitting there, but the victim is getting compensated.
Good. I like that.
Those are the things that we think about, or that I thought about in looking at all of this. You go in and you just look at it and see what has to be done, and then do it.
Well, I like your can-do attitude and your persistence, and you're thinking it through and finding the finding the pressure points, as you say.
Well, I mean, these are, I think, and this is a good part of this conversation, because we've had enough time to really go in, and hopefully people listen to the whole interview, that they understand what's really behind all this, because life has made it so much of sound bites. It's the little 30-second sound bite and everything. And hopefully people will see what it really takes to put something like this together, why it's put together, how it's put together, and how that one little blurb that will go into the box for the legislator, where it's coming from, and how that blurb that the legislator is going to see, should hit them without the long explanation. And maybe we've done a civics class.
I think so. I wonder if another pressure point wouldn't be to find out who their largest donors are and try to get those sort of people on board.
Actually, that is a very, very good suggestion, and it's not that hard. It does take a certain amount of time, because you're looking at 100 assembly people and 20 state senators, because in California right now, there's all of these state assembly is up for re-election. That's 100 people, either election or re-election, because some of them are termed out. And 20 of the 40 state senators are up for election or re-election. What you do, and this is the way you do it, is that I'm doing strategic consulting. I get involved in this a fair amount. What you do is you can go to the Secretary of State's office, and the Secretary of State's office will, or the county registrar, or the counties that people are in, will have a list of the campaign contributions to each one of these individuals. Then you can go down that list because it has the name, address, and telephone number of each contributor.
There might be restrictions on how those lists are used.
No, there
No?
aren't.
Oh, not there. Huh?
Public. We can, because, see, that's how you find out who, for the judges, same thing for the judges. That's how you find out who the big contributors are to the judges and whether it goes over $1,500. So same thing as here. And you go in, then if you have the courage to do it, if this looks like someone that might be sympathetic to the legislation, give them a call and say, hey, look, here's the legislation. If you're sympathetic to it, can you give a call to your donee and say, look, donee,
Yeah.
go in and tell the state senator or the state assembly person that you're really in favor of this and you'd really like to have him go along with it. There's nothing wrong with that.
Good. Because I suggested it.
No, it's
Well, do we have much more to cover?
I think we basically have it. Hang on, let me.
Sure.
No, I turned my phone on to call you. Now I'm turning my phone off.
Oh, there you go. Just turn it off.
Just turn it off, so whoever it is will, they'll either go to voicemail or they'll do something or other.
I'll do the same.
Yeah.
Well, we're just wrapping up, but
So basically, we've got it pretty well covered. The one thing I think we're trying to do here is to get it through quickly, and I think one of the things that I want to leave with all the people that watch, or either watching live or who will watch, is this idea of getting this out to 10 people and having those 10 people get it to another 10 and have those other 10 get it to another 10. And in each of the people, or even if we get 50% of those people doing it, we'll get it to a lot of people. But the thing is to get the legislator on board. And that's going to be important. And the other thing is whatever lobbying groups that they know of. Because to have the lobbying group go in and do something, because the legislators will listen to the lobbying group, because the lobbying group may represent 1,000 people. If you get, Common Cause or something to go in on their imprimatur and say, look, we believe in this. So maybe they may represent 100,000 people. And the legislator knows that they are telling their 100,000 people to do something.
You know what I think is one of the principles that I am really strong about is like trying to bring harmony to the world, and it's usually through bringing opposites together into close proximity. I do this thing where I twist a copper wire back on itself and spin it with a drill.
Mm-hmm.
And it has this profound effect of like canceling electromagnetic waves that come through. Normally an electromagnetic pulse that hits a wire and it creates an induction and a current flow in the wire. Well, if you've got this flow, and when you spin it like this, it creates current that flows both ways and kind of starts to neutralize itself. And it's just, wait a minute, what is the essence here? so I just this one thought occurs to me of like getting um, like groups that normally are at odds with each other to look at this and to come together and put it out, in a lobbying sort of way.
Yeah. Well, actually, I tried something like that in a previous thought of legislation. I thought of raising the salaries of all the judges to the highest level that they're getting under this type of compensation, and then removing, the local compensation. And I figured I would test this out. So I called the California Judges Association and I said to them, "What do you think about this? And are you in favor of that?" And interestingly enough, they were very cool. They really weren't on board, even though that would have ended up helping every judge in California. And by helping the Superior Court judges, it would have automatically raised the compensation of the Court of Appeal justices, who are earning less than Superior Court justices, and the California Supreme Court justices. And I naively thought that they would be in favor of something like that because it would raise the salary of all the judicial officers throughout the state. And they said, "Well, we'll sort of wait and see." And so I said to myself, well, that's really strange, because the organization that should be in favor of getting a higher salary for the judges, coming from an independent source, particularly me, who was screwed over by the judges, would probably be in favor of this, and they weren't. And maybe they weren't in favor of doing something that would possibly reflect that the judges want more money, which they always do. But it was just a very, very interesting thing. And so I reflected on that. The best thing that I could figure out is that they didn't want to be involved with anything that would be coming from anywhere other than from the legislature itself to raise the money of the raise more money for the judges. So the induction theory didn't quite work on that, was it? That's what I'm saying. The bottom line of it. So I figured, well, since they're not going to come out and be in favor of helping the victims, because they weren't in favor of helping the victims before, might as well forget about them and go in with the massive amount of press by the victims themselves, because you got a lot of them. And since the judges really, the other part of it is that the judges themselves don't have enough money to really go in and lobby the legislature. And so any legislator who's afraid of the judges is afraid of a false God, I would say. What they're really afraid of is that the judges will retaliate by not deciding in favor of the legislature if somebody is suing the legislature. Because right now the fix is in. So, so the legislature is saying, look, we've got it made because, we've gone in and we put an SBX 211, so the judges are going to be grateful to us. So they'll sacrifice the populace in favor of the judges. But if we show that the populace has more power, because the populace is the one that votes for the legislature, if they get afraid of losing their job, then the dynamic has changed. So we're working on that dynamic.
It's really been a pleasure to talk with you.
And also particularly to find out another Milwaukeean.
Right. There's a birthday cake somebody's celebrating a birthday, and it's in the neighborhood. So I'm going to probably head on over there.
Okay.
I hear it has ice cream in it too.
Those are the two main things. Ice cream and the birthday cake. Got me. Oh, Joe, it was a pleasure. And anytime that you need me to go on, and push the legislation and stuff, just let me know.
That'd be great. Thank you so much. And
Okay.
Good luck with this. And we'll be watching to see how this progresses.
Yeah. And some of the other stuff that we talk about, the things of Bakersfield and San Francisco and all those things, anything you can do in that area.
Oh, yeah. Bakersfield and San Francisco. You like those two areas. Yeah, I like to try to get more listeners in the Bakersfield area for some of my own reasons. Here's a picture of the state capitol from a time when I ran for office a long time ago.
Oh, wow.
In Wisconsin. When I was a young whippersnapper.
Yeah. I was just thinking, it was on a whole different subject, but I graduated high school in 1957.
Jeez.
So we're looking 57 to 2007 would have been my 50th. 2017 would be my 60th. So 2027 is going to be my 70th anniversary from the graduation of high school. So it's only 5 years off.
Wow. Yeah, I talked to. I met my biological father a couple of years back, and he's from Milwaukee too, and he's telling me all this stuff about like Liberace and the Eagles Club.
Yeah.
That was a big thing in his life. He's always working out there.
Mm-hmm. Oh, yeah. Well, I went to Washington High School. I'm wondering if it even still exists. I guess.
I hear about it. I think it does. I think sometimes when the presidents come through, they might. I think I've gone to a presidential rally, at, and I'm not sure it was Washington, but my brain says that's probably what it was.
Yeah, because that was my high school, and I went to Steuben Junior High. And that was the junior high school, and Sherman Grade School. So those are my three schools. And so.
Wow. See, that was Sherman Park. I lived right next to Sherman Park. I think Titonia went up from there and intersected Silver Spring.
Mm-hmm. Yeah, well, we lived first on 53rd Street, right next to there was a big street that had the trolley buses. I can't remember the name of it right now. And then there was Burleigh was on the other side of it, lived between those two streets. And then we moved up to 55th Street, and that was near Capitol Drive. And then after I left, then my parents moved down to Shorewood, and that was really the last place that they lived, because my mom died there, and then we brought my dad out to California.
There you go.
But I still have. Well, I don't have anyone that's living, any relatives now that are living directly in Milwaukee. I have one relative that's living a little bit north of Milwaukee, and then all the others are spread. So, but it's my parents are buried in Milwaukee. So that's they say it, Milwaukee boy.
Great, thank you so much, and we'll be in touch.
Okay, thank you. It worked out. Okay. All right. Take care.
All right.
Off we go.
Bye-bye.
Bye-bye. Have a good summer. Take care.
You too.
Bye-bye.
Bye.
Bye.
I'm off to have some cake. Joe Baker's Remedy Report is a show about bringing harmony to the world through economic innovations, health tips, and increased awareness. Today's show was on the record. And I'm not using any disclaimers today about it being for entertainment or anything. This one is definitely on the record and has importance to it. Thank you and goodbye for now.